A man fell into a concrete pit, injured his face, brain, and neck. A $6.44 million verdict. Hey everybody, welcome back to the Williams Elleby YouTube channel. I'm Joel Williams. This is my good friend and fellow attorney Matt Stoddard. And today we want to talk to you about a $6.44 million verdict that we obtained together in the state court of Cobb County regarding a situation where a man fell into a concrete pit and got hurt really bad. So before we jump right into that trial and how we obtained that verdict for our client, I want Matt to tell you a little bit about himself.
Well, thank you, Joel. My name's Matt Stoddard, and I'm the owner of the Stoddard Firm. It's in Atlanta, Georgia, right next to Emory University. I started the firm in 2014 after working for a few years with Joel at a different law firm. When I started, it was just me, but at this point, I've grown the law firm to 6 attorneys and some staff, and we take product liability, sex trafficking and racketeering cases, as well as premises liability and wreck cases. The firm holds about 40 to 50 cases at a time, all mostly higher value cases, and we try to work them really hard and prepare each one for trial.
Yep. And one interesting thing about Matt is we first met where we were working for different firms, and Matt was doing defense work, so he was defending people and companies that got sued, and I was on the plaintiffs team in that case, and that was back when we were very young, very green lawyers learning the ropes. So Matt does have a unique perspective on cases because he's worked on both sides. He's defended cases and he's brought cases. But either way, he does it the right way. He's an excellent attorney. He's a good friend. So if you find yourself where you have any cases that fall into the categories he just went over, he'd be a very good option to reach out to figure out, sometimes just to find out if you might have a case. And if you do, be an excellent attorney to hire for those cases. But enough about that. Let's talk about this case. It's a very interesting case, very fun case that we tried for the lawyers. Not fun for our client, but interesting for us. So basic facts of the case. Gentleman goes to a bar and grill. He's invited there by his fiance. He gets there. There's a private party going on. The party is not wrapped up yet. It was supposed to be done by the time he got there, but it wasn't. So he sits down at the bar, has a few drinks. After a few hours, his fiance says, "Hey, would you mind going outside and taking this DJ equipment to your truck so that the DJ can come pick it up at your house? This is a fairly small town where this happened. The DJ can come pick it up at your house tomorrow." He says, "Sure, no problem." He gets up, he takes the DJ equipment outside, tries to get back in, but he's locked out. When he realizes he's locked out, he calls his fiance trying to get back in. He knocks on the doors. He tries different doors to get back in, to no avail. It's dark outside. It's cold. It's raining. He attempts to walk around the side of the building to go to the back to see if there's another door that he can get in. But as he does this, unbeknownst to him, the restaurant and bar had created this condition where there was an unguarded concrete pit that dropped off 11 feet and 7 inches straight down, and because it was dark and there were no lights on in the area, he couldn't see it. He walks off the side, falls on his face, has several fractures in his face. He has a traumatic brain injury. He also has some neck injuries and other areas of his body, but he's hurt really bad and he's taken to the hospital. So this case falls into what we call premises liability cases. It's cases that deal with when someone is hurt on someone else's property, and there's a lot of things that go into these cases. The duty of the property owner, the responsibility of the person that's hurt, how you divvy up fault. But essentially, there are certain things that you have to prove just to win those cases. So Matt, do you want to talk about what's probably the most important thing that you have to prove in premises liability cases?
Sure, thanks Joel for that nice introduction. Premises liability cases are at their root about knowledge. It's about comparing the knowledge and information that the plaintiff had to the knowledge and information that the defendant had about the hazard. And in this case, we had some good facts on that issue. Our client had been to this bar and grill, which was located at a golf course. It's like a country club in a small town. He had been there only a few times and had never been around to this part of the property, and so he didn't know that this pit was there. The defense made a big deal about the fact that the plaintiff knew that the land undulated and had hills, and that's true, but that's not the same as knowing that there's a pit or a drop-off.
Yeah, and we're talking, when we say hill, we're talking about Georgia hills. We're not talking about Colorado hills, right?
True,
yeah.
true. And so we compare that information to the knowledge that the defendant had about their pit. Well, of course, the defendant knew about their pit. It's their pit. But in this case, they knew other things too. They knew their pit was dangerous. There had been bushes surrounding the pit edges, and they had removed those bushes, and the landscaper who removed them told the owner of the property, you need to put up a fence because this is dangerous. There had been times when children had been playing tag near this pit, and the management of the property had to come out and tell them to stop. And they testified, we recognized that someone might fall in, that's why we did that. And there had been a management meeting where it had been discussed, maybe we should do something to guard this pit. A drunk person in a golf cart, because remember it's at a golf course, the Sparring Grill, might fall off, drive off the edge, not paying attention. And so if you look at the knowledge the defendant had versus the knowledge the plaintiff had, things were tipped in our favor. And that's what we kept focusing on, and that's what premises cases are really about.
Yeah. Does the property owner or manager have knowledge, and does their knowledge, is it greater than the person who gets hurt? Because if the person who gets hurt's knowledge is equal to or greater than the property owner or manager, then at least in Georgia, you can't recover. So the property owner or manager has to know more about this hazard than the person who gets hurt. There's different areas talking about actual and constructive knowledge. We won't dig too far into that today. We've got another video if you want to look at it about knowledge and actual and constructive. But what I'd really like to do now is I want to take you guys behind the curtain, behind the scenes, to see things that don't get glamorized in the news, and have Matt sort of walk you through not all, but a Cliff Notes version of how much work goes into just taking a case day one and getting it to a point where you can actually present it to a jury and go to trial. So take us through all the things that were done just to get us up to the trial, Matt.
Sure, I'll take you through most of them. I can't take you through
all
all
of them. Yeah, we've been here for 3 days.
Yeah, so my memory of the way this case started is the way that most case starts, which is I have a long interview with a plaintiff. And I always tell them, please don't try to help yourself in this interview. Just tell us the truth. We can probably win the case if you just tell us the truth. Don't shade anything, tell us how it happened. And so we just try to dig and get as much information as we can from the plaintiff about everything. And we're taking notes while this is happening about where other sources of information are that we can gather. So for example, we learned that somebody called 911, so we can send an open record request and pull a 911 tape. We understand that fire and police showed up, so we can send open record requests and get the fire report and the police report. We figured out where the plaintiff had treated medically, so we can order all of those medical records and bills. And so that's sort of the initial stuff. Also, since it's a premises case, and in some sense the property's on trial, we wanted to learn everything we can about the property. And so in this case, thankfully today we have Google Earth and Google Maps that are pretty darn good. And so using that, we could get a pretty good sense of, take some screenshots of what it looked like out there. I don't believe I went out at that stage, although we did go out later with the defendant's permission. And so we had some photographs of the property. We had some information from from third parties, and from there we typically notify the defendant that we're intending to bring a lawsuit. Please give us your insurance information, which they did, and then we file. After filing a lawsuit, there's a long process of sending document requests to the defendant, subpoenas to third parties, asking written questions of the defendant, and then interviewing under oath any of the witnesses. And while this is happening, the defendant is doing the same thing to us. They're asking us questions. They're asking us for documents, and they're interviewing the plaintiff under oath as well. You do have to know a little bit where to look. They don't always just turn over all the rocks for you, and there's some experience to that. In this case, the most helpful witnesses that we found were some vendors that had done work on the property, as well as some former employees of the groundskeeping staff. and the bartenders that were working that night. And so after interviewing all of those folks under oath, we started to get a sense of what the case was. Also in this case, and this is a little unusual, there was video footage, not showing our client fall, but video footage inside the bar and grill showing him have 6 beers and a shot. And so that was kind of the I'd say up to 2 to 3 months before trial, those were the things that we were doing. The only thing I haven't touched on is we also interview the physicians under oath, so the plaintiff's treating doctors, to try to get a sense of what his damages are.
Yep. And those interviews under oath that Matt's talking about, if you've ever heard the term deposition, that's what we're referring to. It's where both sides lawyers get to go into a room, ask the witness questions, and they have to testify like they were testifying at trial, except there's no judge and there's no jury there. And that allows us to just know what these witnesses are likely to say at trial. And it also creates a written record so that if they say something different at trial, then we can do what we call impeach them, or we can have their prior testimony and say, well, why are you saying something different now at trial than you said 6 months ago when we took your deposition? But yeah, that's a good synopsis. So once discovery, all of this stuff takes place in what we call the discovery phase of the lawsuit, but that discovery phase ends at some point. And once the discovery phase ended, the defendant in this case filed what we call a motion for summary judgment, where they basically asked the court to throw the case out for different legal reasons. So Matt had to fight that and overcome that, and he won those motions so that we could get to trial. And then once the court says, hey, both sides, we're going to try your case this week, or you're on what we call a trial calendar, then that's when a lot of work begins for the presentation. Because one thing we have to work really hard at is making the evidence come in seamlessly. And we work really hard to make it look really easy, right? And so I'd say the trial was in mid-December. Probably mid-October, we really started buckling down and making sure all our exhibits were in order, making sure all our witness testimony was together, divvying up responsibilities for the trial between Matt and myself, so that we would know who was going to be primarily responsible for picking the jury, for opening statements, for different witnesses we were going to ask questions for closing arguments, and all of those kinds of things. And Matt has some staff that provided support for us on that, and so shout out to Bellann and Cooper and Shauna Thomas. Bellann's an attorney that works with Matt, and Shauna is a paralegal for him, and they did a tremendous job of supporting us through to get ready for trial. But ultimately, once you get all of these things done, then the day of reckoning comes, right? And we had tried many times prior to trial to get this case settled. We made more than reasonable offers to the defendant to try to get the case settled. They rejected all of those offers. They made offers to us that would not have resulted in any net recovery for our client. So we really had no choice. And that's one thing I would like for people to realize and understand, is that when cases go to trial and we get these big verdicts, it's very rarely happens after. It very rarely happens unless the person bringing the claim and their attorneys have given the other side many chances to settle the case within their insurance policy limits prior to going to trial, just like we did in this case. But we never got a fair offer, and so they forced our hand, and we're like, okay, well, if you're not going to make a fair offer, then we're going to take advantage of our right to a trial by jury, and we're going to go try the case and see what the jury says. So that's what we did. Cobb County is where we tried the case, and Cobb County, Georgia is it's northwest of Atlanta, if you don't know where Cobb County is at. It's where I live and where I practice. And I love it because Matt likes the concrete in the city. Not so much, but I like being close to the city where we can access it if we need to. But Cobb County is a suburb of Atlanta, and Marietta is the county seat. And so we went in to try this case there, and we picked from jurors that are called in from Cobb County to whittle it down to 12 people who hopefully are neutral and unbiased and have no preconceived notions about what should happen in the case. So the first thing that I handled at trial was the jury selection, which is always a very difficult part of the trial to me, because you have to engage with all of these people you've never seen before. They probably don't trust you because you're a lawyer, and right or wrong, people sometimes don't trust us. But we have to have very meaningful conversations with the jury about issues in the case and about their beliefs and how they look at the world, so that both sides can make sure we have a fair jury. It took quite a while to do jury selection in this case, because there were things like alcohol that was involved. I needed to know people's experience about whether they have had a similar thing happen in their life, whether they're business owners, whether they've ever been sued, whether they have ever experienced or taken care of people with injuries similar to our clients' injuries, whether they've been in a similar situation. And so there were 39 people that we were talking to. We had to have this conversation with all of them. So it took quite a while, but eventually, after about 5-6 hours, something like that, we were able to whittle the jury down to 12 people and one alternate in case something happened during the trial week and somebody wasn't able to be there. So we had 13 total. That happened on Monday. And then on Tuesday, we began opening statements, and Matt handled opening statements. So can you tell us what your goal, what an opening statement is, and what your goal is?
Sure. I'll go back and, if you don't mind, and say a few things about what you just said. Yeah. One thing that Joel was pointing out is that the cases generally only go to trial if the defendant doesn't behave and examine fair offers. Typically, it's not the defendant, and you said this, but just to be clear, it's not the defendant that's deciding, it's the defendant's insurance company. And they were the ones that, really screwed up here. I don't believe it was the defense lawyers. I don't know this for a fact, but everything we know about the defense lawyers is that they behaved with integrity, and that I believe that they were skilled attorneys who were probably adequately evaluating the case. My suspicion is that the insurance company just didn't listen to the defense lawyers. And that's how we ended up here.
That's right. Good point.
And with the voir dire, if I could say, that is a tough spot part for the lawyer, in my opinion. It's hard for one person to have a conversation with 39 people at the same time. And so I'm glad that Joel took on that responsibility and I didn't have to do it.
Well, I'm glad you were there, because, and that's one thing, like if you're a lawyer watching this video, one thing that could be helpful, I know sometimes we're solo attorneys and we don't have the option of having somebody else with us. But if at all possible, during the jury selection process, if you can have another attorney or at a minimum a paralegal there with you, so that you can focus, if you're the one asking the questions, you can focus on that conversation and someone else can take notes for you, so you're not asking a question and then writing and then asking a question and writing. It just helps you remember what people said after this 4, 5, 6 hour process. It's
a lot easier to evaluate potential jurors when you're not the one also talking to 39 of them at once.
That's right.
That's true. And so I had a lot easier time doing that, which made it nice and took a lot of pressure off of me. So hats off to Joel for doing that. I did do the opening statement, and so I have heard, and I think this is true, people tend to remember the first thing you say and the last thing you say the most. And so I worked real hard about thinking about, well, how do you tell this story? What do you want people to focus on, and what do you want them to hear about first? What is this case about, and how do you boil it down to something simple that everyone remembers? And so to me, this case was about a concrete pit that the plaintiff did not know about and that the defendant did know about. The defendant was warned over and over again to do something about their pit, and they didn't do it, and that's what caused the plaintiff to get hurt. That's simple enough and short enough that I think people grasped it. And then I have found that it's always so much easier to use pictures. And so I like to use a lot of pictures. And my opening statements and closing arguments typically have a PowerPoint presentation behind me. The PowerPoint is almost always just pictures. And that they help me in two ways. One, I think they help our jurors see a different perspective and understand what we're talking about. But two, I don't have to memorize things as much because I can look at a picture and go, oh, talk about this now. And so it makes it a lot easier for me to give an opening statement too. With the opening, I'm thinking this is the first time these folks have met me. And so I'm not really advocating. I'll try to be very even, tell them about our strengths, tell them about our weaknesses. They're still trying to decide, is this guy full of crap? Or is he going to be honest with us?
Yep.
And so I try to gain some credibility by just telling it how it is. Not everything's great in this case for the plaintiff, but we should win, and here's why. And so that's how I try to address it.
That's so important too. I think, I know as a younger lawyer, when I would do opening statements, I felt like I needed to advocate at the time, but now, 18 years, a long time into it, I've began to learn that if you have something that's harmful to your case, you need to be the one to tell the jury about it. And opening statement's a great place to do that, because if your case is at trial, it's probably not perfect. Because if it's perfect, this is going to be settled, but there's issues that everybody's going to be wrestling with, and credibility is absolutely the most important thing, because no matter where you're trying the case, whether it's New York City or Miami or Wichita, Kansas, it's if the jury doesn't believe what you're telling them or doesn't trust you, you're toast. You're absolutely toast. So that was very important. Matt did a great job of talking about the strengths and weaknesses and comparing the two and why we should win, despite the weaknesses in the case.
Yeah, I mean, it's definitely a case that had big verdict potential, and we were right. And I believed we were right. I think Joel believed we were right, the jury saw it the same way.
Yeah. So after opening statement, where we've sort of outlined what the case is going to be, then we start what we call the plaintiff's case in chief. And during the plaintiff's case in chief, that's when we call all of the witnesses that we want to call to present evidence. And in this situation, we called one of the bartenders that was working that night. We called our client himself. We called his sister, who was talking about how this affected him. We called some ex-employees of the defendant to talk about what knowledge they had. We called his fiance, that was the bar manager that night, and we also everybody just tells what they know. They don't speculate about things they don't know, but different witnesses know different things. So we have to bring in multiple people to tell the whole story. And then we also called a neurosurgeon who treated our client live, but he wasn't in the courtroom. Matt set it up and asked him the questions by, was it Zoom that you used?
Yeah, it was done through a Zoom application.
Yeah.
I'd say that went good, not great. There was a little bit of a lag. It's the first time I've done that, and I will do it again.
Yeah.
But it's always nice to have them live if you can. But as you can imagine, some of the doctors are not real excited. And I got a surgery. I can't, and I don't even know what time you're asking me to show up. I think it does work better sometimes than just doing a pre-recorded video, which is the other option.
Yeah. And then we also did, and speaking of pre-recorded videos, there was also a spine surgeon and a neurologist, a different neurologist that treated our client. And Matt took their depositions and recorded them on film, and we just played it for the jury during trial. But we had, our witnesses to prove that the club knew about this hazard, that they didn't do anything about it, and then how that caused the damages that we were dealing with in this case. And so, I'm trying to think, is there anything else about the plaintiff's case in chief that is important?
I think we're also trying to play a little bit of defense. I mean, we know what some of the defenses are. As we've mentioned, our client had 6 beers and a shot, and some people are going to say, some people say, if you fall, it's your fault. Now, that's not the rule, but some people think that anyway. And we're dealing with that, plus somebody who's been drinking. But, I mean, this was a bar. It's kind of hard to serve people alcohol and then blame them, you served them alcohol. But we wanted to address that, so we asked the witnesses, how dark was it back there, and was he walking normal, was he slurring, and those sorts of things. And so there's a little bit of defense. I think there's certainly some strategy in our case in chief. I think Joel and I both try to be fairly short with witnesses. It's hard to remember if you put someone on the stand and you ask them question after question, what was that guy really about? What did he tell us? And I've always thought that when the jury's thinking about it later, if they think of a name, this guy was on the stand or this woman was on the stand, what did we learn from her? They're probably going to give you 3 points tops. Right. And so what are those 3 points? And we just try to make sure we hit those 3 points and then move on to the next person.
Yeah, and one thing about the drinking that I wanted to bring up too is it wasn't like our client went to a college frat party and just, pounded 6 beers and did a shot right after, all in 20 minutes. It was over a 4-hour period, so there was time for his body to process some of the alcohol that he had ingested. Now, he was, I think the blood alcohol level was a 0.131.
I don't remember, but it was disputed
right,
because we were trying to push it back to that they did do a blood alcohol at the hospital, but then you could project that backwards. But it was above the legal limit for driving, but he wasn't driving at the time. And there were people at the bar that were acting like a college frat party because you could see the contrast. It was not our client.
That was actually funny because Matt pulls up the video and he's like, "Look, this is our client. This is drunk," and you could tell the difference, and you could see the other guy over there like pounding shots and all that. But so our client was inebriated, but he wasn't like stumbling drunk or anything like that. So some of we saw that on the video, but some of the witnesses that were there, we also used them to testify that he did not appear intoxicated. He didn't appear like he was, over the top, or he had done anything reckless with the amount of drinks over the time that he consumed them. So anything else about the plaintiff's case in chief you can think of?
One thing that was a little unique is we had a judge. I've never had this before.
This was awesome. Yeah.
We had she did a good job. I thought our judge was very fair-minded. She did not do everything we wanted her to do, but she was very fair-minded. But one of the things she did that was unique is she allowed the jurors, after each witness was called, if the jurors had any questions, they could write them on a note card. The note card was then given to the judge, and all the lawyers would go up with the judge and talk about whether or not the judge would ask that question. And so if the jurors had a question that wasn't addressed, it was addressed this way. And that was unique, and I liked it. I don't know what Joel thought about it, but it gave us some insight into what the jury was thinking, and it also, made sure they got all the information they wanted.
That's right. And I liked it, but sometimes it made me nervous because depending on what the question is, it can make you real nervous about your case. And then on the flip side, some questions make you feel really confident about your case, because it gives you some insight into what the jury is thinking. But I liked it because it gives them the full picture. We try to tell the story through opening statement, through our witnesses, and we try to think about everything that we think the jury might feel is important. But we are also human beings, and we can't crawl into the heads of the people in the jury. So sometimes they are thinking about something that we haven't thought about, or they need more information about a specific topic, and that was a good opportunity for them to ask those questions. So that was interesting. I only know of one other judge. There may be more, but I know of one other judge in the state of Georgia that does that, and he's down in Fulton County. But I don't know of very many that take that approach.
Only 2 I've heard of. Yeah. I've never tried a case where it's happened, but I liked it. I would do it again. Now, I'll tell you, sometimes the jury asks questions that for an evidence reason we can't ask.
Right.
I mean, I'm sure most juries are thinking, well, have the medical bills been paid by health insurance? Mm-hmm. In this case, they had not. But that's typically not a question you can ask. Or after the fact, did the defendant fix the hazard so no one else would get hurt? That's also not a question that can ask. And there are good reasons why. So we can't ask those. But, things we missed that they thought were important that we could ask, we asked.
Yeah. And I think the jury appreciated that as well, having that opportunity. But so after we presented our evidence, the defendants file a motion or make a motion in court to have the case thrown out. They wanted to argue that our client was not what we call an invitee, meaning he was there for a business purpose. They wanted to argue that he was a trespasser, or at best for us, what we call a licensee, meaning a social guest, because the duty that's owed to your guest differs according to whether they're there for a business purpose, a social purpose, or if they're trespassing on your property, right?
Yeah, that makes perfect sense. I mean, if somebody breaks into your house at night, they shouldn't be able to sue you if they get hurt because, your stairs are out of code or something. So, you have to be somebody that's like invited to the property. Maybe it's an implied invitation, but, at a business, that's pretty easy because everybody's invited there to eat and drink and, it's implied.
Yeah, if you run a bar, hey, you give me your money, I'll give you this drink or this food or whatever. And so you're invited there for a business purpose, which means that the owner has to exercise a duty of ordinary care or reasonable care to keep their property safe for the people they invite there. And so they were arguing a trespasser standard applied, which we thought was way off the mark, or that a licensee standard applied, which we still thought was off the mark because he had a tab with his drinks on it that showed that he was there for a business purpose. But anyway, we had to argue all those legal motions.
Joel, tell them why did they argue that? I mean, it seems so obvious. What arguments did they have that the plaintiff wasn't invited then?
Yeah. So basically what they did is, I don't think there was any dispute that his fiance invited him to come out there, right? The question was he invited there as a social guest just for her? Or was she inviting him there to, when he got there, was his intent to purchase drinks and things at the bar? Because if his intent was to purchase things and he was allowed in to purchase those things, then he is an invitee. And having a tab showed that he was actually a business customer. The defense wanted to argue that no, he was just going there to see his girlfriend. There wasn't any business intent, which we don't believe the facts played out to show that. But then they also argued that he was only invited if he was invited, he was only invited to the bar area, and that once he walked around the side of the building, that he became a trespasser at that point because the invitation did not extend to that portion of the property. And so we had to overcome those arguments, and the judge actually allowed the jury to decide, was he an invitee? Was he a licensee? Was he a trespasser? And she instructed the jury on all of those different things. So the jury had to decide what his status on the property was. Then they had to apply the legal duty of care according to what status he was in order to determine liability.
I thought it was a crazy argument they were making, to be honest. I mean, the guy had a tab.
Yeah.
He hadn't paid it yet, but he had gotten hurt,
He would have if he hadn't fallen in the pit.
And then that other trespasser argument seems so crazy to me, you're invited until you're just about to get hurt. Then you're not anymore, While you're falling, we've changed the invitation.
Once you're midair, that invitation's done. Yeah, that was crazy, but and listen, there's going to be appeals in this case too. It seems like anyway. And that may be something they appeal, but it goes back to show, like, if this was a $5,000 case, they would have paid it. We would never be here. But they're gonna fight. The worse you're hurt, it's really sad. The worse off you are, the harder the insurance company is gonna fight not to pay you, because it involves more dollars. And it really goes back to, like Chase, my law partner, says all the time. Because one question people ask us is, what's my case worth, right? And sometimes your case is worth $100, sometimes it's worth $100 million. It all just depends on how bad you're hurt. And what I tell people all the time is, like, listen, and Chase tells them this too. I actually got this idea from Chase, but like, you don't want the $1 million case. You do not want to have a case that's worth $1 million, because if you have a case that's worth 7 figures, like, you're hurt pretty bad. Right? If I have a personal injury case, I want it to be $5,000, because that means generally I'm not hurting that bad. I might be hurt a little bit, but I'm not hurting that bad. But if you're talking about big money, there's significant things going on, like in our client's case where he had fractured his face and he had a TBI and he had a neck injury. But when you're dealing with those large dollar amounts, there's going to be appeals. And They went so far in this case, and the next thing after those motions is the defendant's case in chief, right, where they call witnesses and they call experts and people that are there. They went so far in this case as to hire 3 separate experts. They hired an expert to say that the area was within municipal code. We don't believe it was, and we think it's pretty plain according to the applicable municipal code and law that a barrier was required. But they paid somebody to come say that a barrier was not required. They hired was he a
neurosurgeon.
Neurosurgeon. Okay, yeah, I couldn't remember if he was orthopedic or neuro, but he was a neurosurgeon to come and say that this fall from 11 feet didn't cause the injuries we were claiming they caused. And they also hired, who am I missing?
Well, he was a toxicologist, is
yes.
what they call him. So they come in and try to project back the level of alcohol that was in the plaintiff's system. And then that part I didn't really have a problem with. His numbers were a little aggressive, but they weren't off the chart. But then he started trying to talk about, well, what does that mean? How impaired are you? What can... And that seemed a little squishy to me. But I have always thought if you're relying on expert witnesses to prove your case, you're in trouble.
Yeah.
Because you can pick up a phone book and call enough people that eventually somebody, and pay them money, somebody will say what you want. Mm-hmm. So I always take them seriously when the other side does it, but I try not to, hang my hat on what a paid witness is going to say.
Yeah, exactly. And sometimes experts, you have to have experts, like in a medical malpractice case, for example, you have to hire doctors because of legal rules. But if you're hiring an expert to say that somebody that fell off of an 11-foot, 7-inch concrete pit didn't injure their neck, yeah, that kind of goes, a lot of that, regardless of what medical excuse they come up with, a lot of that just kind of goes against common sense, which when you're going against common sense, you're in trouble.
That's how I felt. I didn't have a problem with the toxicologist. I'm not sure he was necessary. I mean, the guy's on video drinking 6 beers in the shot, so they know how much alcohol he had.
Yeah.
But I didn't have a problem with him. The other two, I didn't really agree with that strategy, but that's theirs to make.
Yeah. The code expert was as dry as nails on a chalkboard. I was just like, oh man, I can't believe, he is not entertaining. If you're paying somebody, what were they paying him per hour? Do you remember?
I don't know. Too much.
Yeah, it was a lot of money, but if you're getting paid that much money, you ought to at least be entertaining, and he was not. But they also called the owner of the company, the individual owner, and a different, basically the general manager of the company. And the general manager told us about the tap. That was the first time they had ever disclosed that to us in the entire case. The owner tried to use as an excuse as to why they had not put the fence up, that they had other projects going on, and this was in the middle of the winter, and anybody that plays golf knows that that's the slow season, and they said it was the slow season. And I thought one misstep, if you will, that the defense made is they put a picture up and said, of some stairs on the other side, and said, is this an example of something that another project you had? And he's like, yes, we had to fix those and all this. And I'm thinking, oh, well, they replaced all the stairs. And so I'm thinking, I had 4 months to put this fence up, and I asked the owner there, I said, so how long did it take you to replace these stairs? And he goes, well, we didn't replace them. I'm like, well, what'd you do to them? So we had to put some screws and nails in them. I'm like, are you serious? You're serious right now? That took 4 months? I didn't ask it that way, but that's kind of what I was thinking. I'm like, well, how long did that take? It's like, well, I don't know, not long. So it was going to show the unreasonableness of the actions that the defense made to try to fix or guard against this hazard, and to show that if those things had been done, we wouldn't even be here because Tim wouldn't have fallen.
Yeah, and these the defense lawyers in this case and in all the cases, they don't pick the facts. Fortunately for Joel and myself, folks call us and tell us they have a case and they want to bring a lawsuit. We investigate, and oftentimes in my office, and I'm sure it's exactly the same for Joel, but oftentimes in my office, we say, no, I don't think that's a case that we can win. But when one of these defendants gets sued, the insurance company that they've done business with hires a law firm. The law firm doesn't say, oh, well, that's a loser. We're not taking that case.
Yeah.
So, I mean, these they were good defense lawyers, and they really did a good job with the facts they had. But, you know, they don't pick the facts.
Yep.
And so it's tough sometimes. These insurance companies put them in a tight spot. At least they did in this case.
Yeah, that's right. So after the defense finished calling its witnesses and introducing its exhibits, the final thing that happens before the jury begins deliberations or trying to decide who prevails in the case is closing arguments. And in Georgia, if the defense presents evidence, then the plaintiff gets what we call first close and second close. So you get to summarize the facts, and then the defense gives their closing argument, and then the plaintiff gets the last word because the plaintiff has the burden of proof. And so Matt and I split duties with the closing argument. I didn't spend a whole lot of time in my closing argument. I just kind of summed up the no-brainer, just write their facts to remind the jury, hey, this is not a difficult case. This is what the evidence showed. This is what this person said, and this is why we should win. The defense gave their closing argument and basically contested everything. They contested fault. They contested whether Tim was hurt as bad as we said he was, everything. And I felt like it kind of went a little overboard. Like, they had some decent arguments. Like, I thought one good argument they had was, well, he should have turned the flashlight on his phone. And he didn't do that because he was trying to call inside. But it was just the fact that, you know, he had access to a flashlight and had not used it. So, and if you're Monday morning quarterbacking it, some people could say, well, yeah, that didn't really make sense to me why I didn't turn the flashlight on, but he's trying to call to get help. So it was just the fact that wasn't necessarily in our favor. It was more favorable to the defense, and I would have focused a lot on that if I were them, but they focused on everything and refused the entire time to admit that they were any percent at fault for what happened here, which I thought lost them some credibility. And Matt and I had a long discussion about whether we should accept on behalf of our client any percentage of fault, and we ultimately decided that we would. And so in Matt's portion of the closing argument, that was one thing that he covered, but he also asked for the jury award of damages and all that. So you want to tell us a little bit about how you approached your portion of the closing argument?
Yeah, I'd be happy to. Before I'll do, I'll tell you though that Joel did in his first close, he's correct that it was simplistic. It just sort of brought, you know, the very sort of short slides of here's the facts that matter and the rest of it's noise. And he must have done a great job with it. I know he did, because when we were talking to the jury afterwards, one of them walked up to him and said, "Can I have a business card, please?" So he must have done a good job. So yeah, you know, that final close is, I always think, the most fun part of the trial. Inevitably, I've yet to have a case where the defense lawyer didn't say something that I just didn't think was true, and it's my opportunity to come right back and say that's not right. And that was done here as well. There were some arguments made that I felt like the facts didn't support. So using, you know, evidence, photographs, and documents, we were able to say, no, that's not correct. Look at this, and this, and, you know, always trying to keep that credibility. But at this point, it's okay to advocate. And so we did some of that. Went through a lot of what some of the witnesses said, went through some of the law and, you know, how it should be applied to these facts, and then talked at the end about what the appropriate amount was. And that wasn't something that I came up with on my own. It was a collaborative, it was a conversation, not just even myself and Joel. We had a visual media person with us who's seen a lot of trials, that our client. We had some staff, and everybody kind of came together with, well, how do you present this? The easy thing is the medical bills. That's easy. And I think they were just over $300,000. But in this case, there was a permanent brain injury. And so I thought that was a very significant, very significant injury. It's just nothing you can do about it. And, you know, he's not going to think as quickly as he had. He's not going to remember things as well as he had for the rest of his life. And so I thought the way to do it after that discussion was to break it down. There were a lot of different injuries and say, well, this is the stuff that healed, this is the stuff that is, healed quickly or healed over time, and then this is the stuff that's permanent, and tried to give numbers for each. And said, well, what if the jury doesn't agree with us on this spine injury, for example? Let's break that out as a different number so they can delete that from their equation. And just kind of looked at it that way, tried to be fair, but also I think the credibility is earned or not earned at this point. And whether or not the jury agrees with your numbers, I think has a lot to do with how you acted during the trial, because they don't know
whether you were honest with them during the trial.
That's right. They don't really know what's normal. We kind of know what's normal because we see other settlements and verdicts, and I mean we don't know exactly what the jury's going to do, but we can give you a range and say, well, here's the range that we think the damages are probably in. Now we're not allowed to tell the jury, well, this other jury did this with something similar.
Right.
But we kind of know what it is, and so if we've gotten that credibility and that honesty from 4 or 5 days of behaving, hopefully they say, well, these guys must seem to know what they're talking about. That seems about right.
Yeah.
And so that's what we did here.
Yep. And we also, in Georgia, we have what's called apportionment of damages. And sometimes fault can be apportioned to people that aren't even in the lawsuit. Oftentimes, percentages of fault is divided up between the defendant, and the jury may say, well, we think plaintiff, you bear some responsibility for fault, so they'll assign a percentage to the plaintiff. If the plaintiff in Georgia is 50% or more at fault, they get nothing. If they're less than 50% at fault, they can still recover, but the overall damages are then reduced by that percentage of fault. So if a jury says, well, we think you've got $10 in damages, but the plaintiff, you're 20% at fault, then the judge will then reduce that $10 by 20% or $2, and the plaintiff will recover $8. And it goes all the way up to 49.99%, but once it hits 50, the dollar recovery goes to zero. So we were trying to figure out what percentage we could suggest that the jury assign to our client. And Matt gave them a range, and kind of in the middle of that range was 25%. And Matt said, look, we think that would be fair. And that's exactly what the jury did, is they found the defendant to be 75% at fault for the choices they made based on the information they had, and they found our client to be 25% at fault for the choices he made based on the information he had, which I thought was a fair and equitable way to do it. Certainly, any reasonable person could have come to that conclusion, and so the ultimate award, the overall damages was $6.44 million. The compensatory damages portion of that was 4.6, and so that amount was reduced by 25%. But the jury also awarded our client attorney's fees based upon the bad conduct of the defendant, and believing that the knowledge they had of this danger was so great that their conscious decision not to guard against it was done in bad faith, which in Georgia means conscious indifference to the consequences of your actions or inactions. So they knew it was dangerous. They made the conscious decision not to fix it or guard against it, and that showed that they were indifferent to any consequences that could result in them not putting this fence up. And in those situations, attorney's fees can be awarded, and so they were awarded in this case. But so that's kind of where we're at now, right? I mean, the verdict has come in. There may be additional damages such as interest and additional attorney's fees or expenses added onto it, depending on what choices the defendant's insurance company makes now as to whether they want to do the right thing and pay it or whether they want to appeal it. But the fact of the matter is that when I look at this case, there are two things that are very sad to me. One, it's sad that this ever happened to begin with, because somebody's life was changed forever because of the decisions the defendant made. Two, it's very sad that the insurance company for the defendant in this case did not settle the case when they had many opportunities to do so. within the business's insurance limits, because that's what we pay insurance companies to do. We pay them to protect us when we make mistakes and maybe hurt somebody or cause property damage. And sometimes they do their job that we pay them to do, and they'll take care of it. Sometimes they don't. But in this case, they didn't, and it resulted in a verdict that exceeds the defendant's insurance policy limits. So now the defendant technically is responsible to pay anything in addition to it. And we believe that the reason they're in this position now is because the insurer did not settle the case when they had a chance to do so. In fact, one thing that we haven't talked about is after closing arguments, we made what we call a high-low offer to the defendant. If I'm remembering the numbers correctly, we said we'll do a high-low of $1.5 million to $465.
That sounds about right. I believe it's in an email somewhere.
Somewhere in those numbers, right? And basically what that means is that the plaintiff was going to agree that if the verdict came back at $1.5 million or more, no matter, it could be $50 million, he would agree to accept only $1.5 million. So it limited the exposure of the defendant to an amount within their insurance policy limits. But on the flip side is that if it was a defense verdict, or if it came back at $100,000, the defendant would still pay $465,000. And then if the verdict came back somewhere in between those numbers, then the defendant would just pay that number.
The great thing about that is under that deal, if they had taken it, the defendant was supposed to pay the money very quickly, so there wouldn't be any appeals, and that is oftentimes important to our client. Not a man of means, it has these health problems, and closure is also mentally helpful sometimes.
Yeah, and so all indications right now is that there will be an appeal, and it's going to have to work its way up through the Court of Appeals of Georgia, possibly the Georgia Supreme Court. And we'll see what they do and what the defendants actually appeal. But all in all, it was a good verdict and judgment for a very deserving client of ours. It was an honor to represent him, and we haven't said his name during this case. This stuff's public record, so if you really wanted to know, you could go dig into the public records in Cobb County. But just out of respect for him, we're not using his name here. But yeah, it was great to try another case with Matt. We've tried 2 cases together before. I think the first case, it may not be a record now, but the first case we tried up in Hart County, I believe, was pretty close to the highest recovery in a jury verdict in that county. I think there's been one higher than that since, but very conservative place. And so yeah, we've had fun. We've worked against each other. We've worked with each other. We now have different firms, and we had the opportunity to come back and try a case together, which was a blast. So you got anything else regarding this case that you think the folks ought to know?
It was a pleasure to try a case again with my friend, who the first case I ever tried was with Joe Williams.
This is true.
So it's great to do it again.
Yep. And the one thing you remember, that the defense attorney, I guess his name is Hugh McNatt. He's deceased now, but we ended up becoming friends after that trial because he also practiced law, in my opinion, the right way. He would defend really hard when he needed to. He would pay settlements when he needed to. But in that case, when we were trying to get it settled prior to trial, he said, "Joel, I don't make the facts. I don't change the facts. I try the facts." And that has stuck with me all these many years since we tried that case, and it's something that I have tried to implement into my law practice. And I could tell when we were trying this case that you have implemented that strategy into your law practice too. And so, yeah, that's it. If you're still watching this video, you are awesome, and we appreciate you sticking with us this long. But we wanted to give you the backstory on this case and what really happened behind the scenes and what happened in the courtroom. But if the video's been interesting to you, we'd appreciate you giving us a thumbs up. Hit that subscribe button, and you can be up to date on any new videos we put out, any other guests that we may have in from time to time. But yeah, thanks for sticking with us, and we will see you next week for another video.